As a fallback position, 1992, we realized, well, we're not getting anywhere in the political negotiation process. So we fell back on Section 35. And in 1993, we started defending our people in the courts when they were charged with hunting and fishing. So in 1998, for example, the Powleys were charged at Sault Ste. Marie for shooting a moose and tagging it saying, "Meat for the winter," based on our Métis rights. And the Supreme Court of Canada in 2003 said, yes, the Métis of Sault Ste. Marie area have existing Aboriginal right to hunt, and that the Métis are a full-fledged rights-bearing people. And they also said there is no hierarchy between peoples with respect to rights. In other words, Indian rights are no greater than ours, or our rights are no greater than Indian rights or Inuit rights. They said there is no hierarchy in rights. So it's a very significant case. This past few months, basically this summer, in July, the Supreme Court of Canada also came down with another significant decision with respect to the Métis, this dealing with the Métis settlements in Alberta. And the Métis settlements, for you that don't know, in 1938, the Alberta government set aside Métis, what they call colonies, for Métis by lakes and forests, so people could go, Métis people destitute, or people that could not make a living elsewhere could move on to and hunt and fish and trap and do some farming. That was 1938. And so there is a provision in the Alberta legislation that if you choose to become a status Indian, you're no longer eligible to be Métis for the purposes of living on those settlements. So that an issue came about. I won't say how, but an issue came about, and the Cunninghams took that to court. And the Supreme Court of Canada, in the end, in July, basically said that the Métis have a right to determine their own citizenship. And I won't go any further because Kathy Hodgson-Smith is going to speak about that particular case. I just want to say that. So governments are recognizing that we do have rights. For example, the federal government in the early mid-1990s put out a document called it's a policy on the implementation of the inherent right of self-government. Now they list a whole list of things that people on a land base can negotiate. And for us, we're categorized, Aboriginal people off a land base. And basically it's very negligible what we can negotiate with them. Devolution of programs and services is one thing. We haven't even done that. But the important part is that they say that they recognize that the inherent right of self-government of the Aboriginal peoples is contained in Section 35(1) of the Constitution, and that it doesn't have to be defined any further. That's the point I want to make. Okay, so we can say clearly that we do have the inherent right of self-government, and we know there's a policy that acknowledges that. And the courts are beginning not to give us anything, they're not granting us anything, they're recognizing our assertions. For example, in Powley, they identified, the criteria for who is Métis. And basically it coincides with the 2002 declaration or adoption of the definition or the criteria by, our General Assembly government of the Métis Nation. So basically it's something that's, it's a fundamental part of us, and it has had recognition. As well, not only does the Métis National Council represent the Métis Nation within Canada, it also represents the Métis Nation internationally in the different institutions of the United Nations and in the Organization of American States, and in other forms. So we are going out there. We are saying we're a nation. We do say that we have the inherent right of self-government. So what we're saying now, almost 30 years after reforming ourselves into a government, that it's time for us to adopt a political document that sets out our governance system, where we can use this in the courts, we can use it in the political forums, we can use it internationally to say, not only are we saying we're a nation, but here is our political document that asserts our nationhood. And so, as I say, we're getting close to a consensus on that. Now, in December of last year, 2010, our General Assembly, our government, national government, adopted a resolution which set out a process which hopefully will arrive with a constitution in hand. Essentially, they've mandated, as Gary has stated, the Métis Rights Panel to act as the commission or subcommittee of the Rights Panel to do these consultations over the next 2.5 years. So Alan Moran, who's the vice chair of the Métis Rights Panel, I being the chair of the panel, will go to each province, and we've been to Manitoba a couple weeks ago. And in Manitoba, the Rights Panel member, Claire Riddle, sat with us there. Today we're in this province, so Gary is part of it here. And so we will be traveling and we will be meeting on a constant basis, all of us, to continue seeing what progress we're making. But in any event, for 2011, 2012, this fiscal year, it's an introductory process, as we're doing today. We're hoping to meet as many people in General Assemblies as possible. We're hoping to get invitations to board meetings as well. And in December, we have a proposed workshop where the boards of the 5 governing members will be invited for us to have this dialogue. We're hoping to do this on December 11th and 12th, which will then have us in Ottawa for the 13th, when the Manitoba case, land rights case, is being argued in the Supreme Court of Canada.